Welcome to the final video lesson on wrongful convictions worldwide. This last lesson deals with the issue of compensation for the wrongly convicted. 43 babies dead in suspicious circumstances. This was the mystery that riveted Canadians in the early 1980s, particularly since the deaths took place within the halls of the prestigious and world-renowned Hospital for Sick Children in Toronto. In January 1981, an autopsy of one child revealed a high level of digoxin in her blood. More autopsies followed with the same findings. The police were called in and focused their investigation on the pediatric nurses in the wards where the babies were mysteriously dying. An examination of work logs initially pointed to nurse Susan Nellis, who was on duty when the first 3 deaths occurred and on duty just before the 4th death. Ms. Nellis, who knew she was about to be interviewed by the police, received advice from her law student roommate to, quote, lawyer up, end quote, before going any further. When detectives from the Toronto Police Force made arrangements for her interview, she advised that she wished counsel to be present. That request convinced the police she was guilty, leading to an indictment on 4 charges of first-degree murder. At the preliminary inquiry, proof was provided that after Susan Nellis had been relieved of her duties, another infant died at a time when she had been off work for several days. The judge at the inquiry dismissed all charges. Nonetheless, Susan Nellis was not finished with the legal system. She issued action against both the Toronto Police and the Attorney General of Ontario as the employer of the prosecuting Crown Counsel. The allegation was that the defendants acted with malice in the investigation and prosecution of these crimes. The case made its way to the Supreme Court of Canada in 1989 and stands for the proposition that the Provincial Attorney General is not immune for actions of malicious prosecution. This decision became the cornerstone of Canadian law on the liability of the state and the availability of compensation for victims of the criminal justice system. In the other common law jurisdictions, however, the state remains immune from lawsuits alleging malicious conduct on the part of police and the prosecution. Jacqueline Hill, age 20, was a third-year English student at the University of Leeds on November 17, 1980. That evening, she attended a probation officer seminar at the Leeds City Centre and then caught a bus to take her home. At 9:23 p.m., she disembarked across the road from the Arndale Shopping Centre and commenced the walk to her residence. At the same time, Peter Sutcliffe was sitting in his car parked outside the shopping center. Upon seeing Miss Hill, he turned on the ignition and drove just past her. He then got out of his car and followed her for a short distance before delivering a blow to her head with a hammer. Moments later, another woman appeared on the same road. Sutcliffe quickly dragged his victim to a vacant spot behind the shopping center. Once he was confident he could not be seen, he tore off Miss Hill's clothes and stabbed her repeatedly with a screwdriver in the chest and eye. At the scene of the initial attack at the front of the Arndale Mall, another student found a purse with what appeared to have blood upon it and called the police. Members of the West Yorkshire Constabulary performed a cursory search but found nothing. It was not until the next morning that an employee of the shopping center found Jacqueline Hill's body and what would become the last known victim of the Yorkshire Ripper. Miss Hill's mother sued the Chief Constable of West Yorkshire, claiming on behalf of her daughter's estate damages for the negligent investigation by the police. The case wound its way to the House of Lords, where it was held that the police have a blanket immunity for allegations of negligence. This jurisprudence includes actions by the wrongly convicted for shoddy investigations leading to wrongful convictions. Only Canada allows an action for such negligence. Leaving behind tort claims, it is universally accepted that the availability of statutory schemes to compensate wrongful convictions is the most principled process. The 2 common law jurisdictions that have provided this recourse are the United States and the United Kingdom. In America, individual states are free to address this issue as they see fit. 35 states, plus the District of Columbia and the federal government, have compensation statutes to address the harms caused by wrongful convictions. There are differences between the states found in eligibility requirements, limitations on awards, questions of factual innocence, burdens of proof, prior criminal history, and limitation periods. The available compensation ranges from $5,000 per year of wrongful incarceration with a maximum payout of $25,000 to the relatively generous payout of $80,000 per year in Texas, which at the same time is the state that executes more inmates than anywhere else. So if Texas doesn't kill you, it will pay you. In the UK, Section 133 of the Criminal Justice Act of 1988 creates an enforceable right to compensation by way of application to the Secretary of State. In 2014, however, this act was amended to require a claimant to prove that there was a new or newly discovered fact that showed beyond a reasonable doubt that the exonerated individual was factually innocent. This threshold has made access to the British statutory scheme virtually useless. The last recourse is the non-statutory regime of the prerogative of mercy, exercised by the state in what is a totally non-transparent process. This avenue is referred to as an ex gratia or out of grace scheme. All common law jurisdictions have had schemes in place for decades, except for the United Kingdom, which abolished theirs in 2006. Canada has had an ex gratia scheme since 1988. Since then, there have been 25 payouts in over 30 years. Although there have been very few successful applications under this particular route, it has provided for payments in the millions of dollars for high-profile cases involving egregious miscarriages of justice. New Zealand has established guidelines for a non-statutory scheme, which is published online and readily available to potential claimants. This scheme is the most transparent for virtually all jurisdictions. It allows a starting figure of $100,000 for each year of wrongful incarceration. The jurisdictions in continental Europe appear to take a more principled approach than the common law, with primary reliance on human rights obligations to drive the opportunity for compensation. Payments are available irrespective of failure or fault on the part of the police or the prosecution services. And that brings us to the end of this academia course on wrongful convictions worldwide. I hope you've enjoyed the lessons I prepared and that you have learned why, once again, that wrongful convictions are the civil rights movement of the 21st century. Thank you very much. It has been a pleasure.